chats, and if any questions come up, we'll let you know. So Mike, Amanda, floor is yours.
Thank you, and good afternoon, everybody. Mike and I both do a lot of workshops and trainings and things like that, and our view always is our highest and best use of our time is to answer the questions you actually have. So feel free to interrupt us with questions if you have them. Otherwise, we thought we might just take you through our experience over the last year in requesting and mostly not getting COVID data. And we can tell you about the status of a case that we have going on. So the first thing we thought we'd do would be to just sort of highlight for you the statutes that are at play. And I'll try to remember to say this again later on. But one of the things that we can share with you is the letter we sent to DHHS requesting information and data. So if you'd like a copy of that letter to use as a template, you can email either one of us. Mike is mike@smvt.com, and I'm amartin@smvt.com. But we recited these statutes in our letter because one of the things we thought was important to do was to sort of distinguish and delineate what COVID data was and was not in our sites. So Mike, tell me if you have experienced differently, but I have not had a single question from a reporter trying to get information about any person. All of our clients have been requesting aggregated data. So either aggregated data for X county or data for the state, or what seemed to start, I think, causing most of the friction were requests for data from particular facilities, whether they were, meat processing plants, prisons, nursing homes, things like that. So to start, we just thought we would talk about what the law protects, and not surprisingly, what the law protects is confidential patient information. So there are two places in the North Carolina statutes that address this. 130A-12 describes privileged patient medical information. So that's pretty clear to us that it's not saying, what have been the outbreaks at Central Prison or something like that. And then later in the statute, it gets even more specific in talking about what information about communicable diseases. It talks about information that identifies a person. And so we think it's important to underscore that again and again in any overture that you make to try to get information. And then the North Carolina law works in conjunction with the federal law. It sort of borrows some of the definitions of the federal law. And you can see there, again, it's talking about individually identifiable health information. So that's the backdrop over which we were making requests. Mike, you want to kind of do the sort of the overview approach on this in particular, but in general?
In I guess exactly what are you saying? Wanting me to cover, Amanda, so that
on just sort of this basic approach of whether a document or a record. Are you seeing my screen?
I am now. I was looking at something else.
Sorry.
Obviously you're allowed to get public records, and the documents that are made or received by a public agency can only be withheld if they're specifically exempted. It would seem like that's fairly obvious at this point, 20 plus years into the most major revision of the public records law. It's actually approaching 30 years, I guess. But as recently as yesterday, I was in a hearing where somebody was trying to argue an exemption by analogy. It has to be a specific exemption, and any exemption, our case law says, is to be construed narrowly, and you err on the side of openness. You don't have a requirement to do this, but I think in the context we have regularly counseled people to make specific that you're not requesting confidential information. If there is an exemption, make clear, I'm not trying to get this particular information. I'm not asking you for it. I'm going to put a little asterisk right there because you might want to ask for it, and Amanda's going to get to why you might be able to get that information coming up. And then obviously, you're also making clear, we made this clear in our letter to the General Counsel for DHHS, that we're not requesting specific patient information or specific individual information. Early on, a lot of what we were getting, our reporters were getting and making requests was, well, you know, there are only a couple of people who have COVID in that facility, and so you'd be able to figure it out. And I still haven't been able to figure out how they would be able to do that. To know that there are 2 out of 300 beds, and that, you know, one as a patient and one as a staff member is hardly going to identify somebody in a congregate living facility or a prison or a meat packing plant. There is a bit of a disconnect in the meat packing plant. Early on, I worked a lot with the collaborative that developed in February, March of last year, and there was a disconnect with respect to who has the data that you're requesting, and that's not always abundantly obvious. And so part of what we can help you with, and we've helped others with, is where does this data reside, if it resides at all? Are they to be reporting data and they're not getting it, or are they you know, suggesting that it not be given so it's not accessible? Those questions can be asked
Mike,
about specific things. Sure.
do you think, I sort of think that may be one of the most productive things of the letter campaign and litigation that we had. I think it might have helped push at least to get some of that more timely reported. You want to talk about the dashboard?
Sure. So very early on, in conjunction with not only the collaborative, but then a coalition that developed, we wrote a letter to one of Amanda's and my wife's good friends, who is Betsy Tilson. Amanda and my wife and many others that I know very well have been in the same book club for 25 years, I guess now. And we asked Dr. Tilson to take the statutes that Amanda just referred to and some others that are in the same line and err on the side of openness, that this was a very serious problem and that gaining access to this information was paramount for all of us, not in a prurient sense or not in a macabre sense or not in a shaming sense, but in a, we need to understand what's going on and gather this information. I'm sure she was busy and my first letter was ignored, and we sent a follow-up to that, and ultimately we got a, you know, we appreciate your efforts. We'll get back to you on some of the requests. And one of the main requests was, give us access to your database or your field record layout for your database, and we'll tell you what data streams we want, and we can help you disseminate this information about infection rates and places and things like that. And over time, while they did not, I don't believe we've had access to the database yet, the DHHS has been publishing an updated dashboard that's more and more robust. There have been times where there have been data gaps or delays in putting up data, and that has evolved over time. And certainly the dashboard that was came about early last year is far more robust. And I hope that our clients in pushing on that were quite helpful.
I think we may have a question. Oh, no, it's Phil saying he'll post. So I remembered that we did prepare kind of a sample of what a request might look like. And I'll share that screen. So we just think you ought to walk through what it is that you're asking for. And one of the things that we often discuss is ask for things you know exist and describe the things that might be out there that you don't know exist. That's always a good idea to sort of cast the net widely, but then to include this recitation of what you're not asking for, to include this recitation from the School of Government, which is looked to us to be pretty clear, although so far we haven't gotten a lot of buy-in from the government, despite the School of Government saying this. But there are a couple of postings on the School of Government website about interpreting these laws, and this statement comes from one of those. Both HIPAA and the state communicable disease confidentiality law allow disclosure of communicable disease information that doesn't identify individuals. And then we always include language about how these laws should be interpreted broadly, as Mike said. I'll come over and pull up the specific letter to to Lisa Corbett, which includes, I think, the language that Mike was just referencing. That they have latitude. And we often have this conversation with regard to information and records from the police department or personnel information when people sort of say, I'd love to give you this, but I just can't. My hands are tied. And one of the things that we think is useful is to call that bluff. So in several of those circumstances, the statute has sort of an escape valve that says if they want to give you information, they can make a decision to do it in their discretion. And that's here in the letter to Lisa Corbett, in which we sort of describe why we think this information should be released and can be released. So that's often a way to kind of stop somebody from, whoever it is that said blowing smoke up your skirt, to say, you know, you can release it if you want to. And so it's worthwhile to remind them of that.
One of the interesting things that I found out in going through this process is North Carolina law actually incorporates in the administrative code a publication by the American Public Health Association called Control of Communicable Diseases Manual. And it's a compendium put out by the APHA. And in that, there are 2 chapters that specifically address the absolute critical need to establish regular communication and provide as much information as possible when dealing with a major public health crisis. Obviously, while those things are certainly written in the aftermath of the 1918 situation, none of them were written in the context of what we've been dealing with since last March. As it turns out, it took me months to get access to that manual. It's something you can get online. I don't know if I can, let's see if I can share a screen here. I can't. So you should be able to see the, let's try it again. Well, it just wants to share my calendar with me.
Now we're seeing it.
You were seeing the website?
Yeah.
Okay, so let me try that one more time. So you should be seeing the website. That is the manual. You can order it online. You can get electronic access. And there are 2 chapters. That deal with how to deal with mass gatherings, and I can talk about why that was important for me. And then also on communicating during a pandemic. Basically, the overall crux of those chapters are that it's really important to get out front in communication, provide as much data and information as you can, and update it regularly so that people can make decisions about how they're going to live their lives. That was a lot of the conversation that we had at the outset. I should say that Amanda and I, after sending that letter to Ms. Corbett and her counterpart at Department of Public Safety, did our best to, say to them, this is not adversary. This information is important, and we have a statewide, if not nationwide, network of people who can help distribute this information. I think it was listened to, but I don't know how effective we were in convincing them that we were trying to help and not solely report on the foibles and pitfalls.
It's been hard through the pandemic for us in this context and in other areas of government transparency to really tease out what was like, look, we're just swamped, we're busy, we don't have time for you, versus we're worried about releasing this information and so we really don't want to, versus we don't think we can, which I think that's last on the list. But there has been this problem at each point in figuring out how to draw out. In this case, it was the lawyers and the public officials. We've had issues in getting access to courtrooms, in which sometimes I think the courthouse officials have thought we're following the governor's order, and so nobody can come in unless you have to be here. That's not right. Versus people taking advantage to say, oh, we have a new tool to keep you out. And I would say that has been most problematic in the context of open meetings. That it is a variation on the theme that was advertised today, but the General Assembly passed what I sort of call an emergency open meetings law, and that is a new way that public bodies can meet during declared states of emergency. And those provisions allow for a public body to do remote meetings, provided they do a lot of other things too, like streaming and having available a way for people to make comments and things like that. But what I have been hearing about in the last couple of 3 weeks are public bodies that are trying to create their own intermediate, which is, we're going to all get in one room, but you're going to be somewhere else. And if you read the language of the statute, that's not allowed. We have 2 laws in North Carolina that relate to meetings of public bodies. One is this emergency open meeting statute that says if they have a remote meeting, that is defined as a meeting at which one person at least from the public body is participating remotely. If they do that, then they can do these other things like excluding the public. But if they're not doing that, then in my view, they're just under the regular old open meetings law. And in that circumstance, they have to let the public in. And so I think some of these bodies are getting up to the declared maximum of 10 people with just their, the body plus a lawyer plus a clerk. But if they can't let the public in, I think that says then you've got to do a remote meeting. And the very first time I heard about this and started thinking about it, I thought, well, they're just going to start sending one person home so that they technically comply with the law. So what are we really gaining to insist on that? But I've come around in my thinking, because I think if they send one person home, then that person's going to insist that the tech works, that the streaming works, that, if the meeting drops off, that they have to hold on until it gets reconnected. I think there are a lot of things that you gain by having even just one member of the public body remote. So we're in many respects kind of feeling our way through all of this, but we are trying to use the tools we have And in the public records context, getting information from these health agencies, I think the tools are that the documents are public unless they're exempted, and we don't think they're exempted. Mike, you want to give sort of the tortured course our litigation has followed?
Sorry about that. That barking you heard was my golden retriever saying hello to the mailman. We filed a lawsuit on behalf of a fairly large coalition seeking information from the DHHS, DPS, and the governor's office. And the first lesson was that while the governor is in charge of both DHHS and DPS and working very closely with them, none of the records requests were specifically copied to the governor's office. And so the attorney general's office moved to dismiss the governor as the party defendant. And he was dismissed. And so, while we see him standing near or with Dr. Cohen, multiple times each week, that was the court's decision to let him out. In addition, there is a provision that was added to the public records law now several years ago, which requires mediation of public records disputes. Oh, goodness gracious, now we have both dogs saying hello to the mailman, and I apologize for that. The mediation requirement, in my view, is not mandatory if the parties agree that we don't have to go through mediation. Of late, the Attorney General's office has insisted on mediation. We held a mediation very early on when people were new to that technology via Zoom. To say it was a nightmare is being an understatement. At one point, I had my cell phone sitting on my computer so that at least one, if not two, of the reporters who got dropped off the Zoom could hear, and then I would have to translate from time to time if they wanted to participate. And then some people couldn't get in at all. But we spent all day going through this mediation and got literally nowhere, trying to figure out what people's status and positions were. While this delay was happening in getting the mediation scheduled, the defendants slowly started to produce some of the information. And so it was a bit of a game of whack-a-mole. Well, we went back to try to have our immediate hearing, and the defendant said, well, not all representatives of the plaintiffs were there, and so we need to have mediation again. And we went back and did yet another mediation all day long. We got nowhere. So we ended up with our immediate hearing several months after filing the lawsuit. And in the first 15 minutes of my part of the hearing, a giant storm whipped up in North Raleigh and blew up a transformer, and we lost all connection to the internet, and we couldn't proceed with the hearing. We've had a very difficult time getting that hearing and several others back on the calendar, but we keep trying to do that, and hopefully that will be scheduled soon. That has been another problem in the calculus of what do we do about not getting information, because the reality is getting into court and in front of a judge to push the matter along has been exacerbated by all of this. Just off note.
It's always worth repeating it a time or two, just some generalized best practices. But one thing that strikes me right now is we are very vulnerable to getting, pushed to the end of the line. And sometimes the requests that we send are so big that we get that answer back. People saying, oh, well, this is just going to take forever, and so we'll get back to you, after the pandemic or whatever. That has made me come to think that perhaps one thing to do might be to really just sort of break some of these down, or just make bite-sized requests. And here's one thing that is tempting to do, but avoid it. And that is, it's tempting to just ask for information. But under the North Carolina Public Records Law, any of you who've called the hotline on this type of issue have heard us say this before. Under the Public Records Law, they don't have to answer your questions. They don't have to give you an interview. They don't have to give you the time of day. Under the Public Records Law, they do have to give you documents, though. And so one thing to think about when you write your request is, be clear what it is that you're interested in, what information you're interested in. And I think it's fine. In fact, I think it's a great idea to put in a letter, I'd be happy to discuss this if there's anything that needs clarification or anything like that. But at the end of the day, your request has to be for a record, or at least it has to include a request for a record. So that's why we sometimes have the sort of awkwardly worded, any document reflecting X, Y, or Z. And it's just a way to make sure. I mean, early in my open government litigation, we actually had a case that got dismissed because the client had not asked for a record, but had just asked for information. So I think that's worth remembering. Also, asking for information to be provided as it's available. If what you're asking for is something other than just a single record, if it's a group of records, be clear that you'll take it as it comes. So again, you don't get just shoved in a corner. I learned this tip from a Carolina Public Press reporter years ago. First thing you do, it's not kill all the lawyers. First thing you do is make a copy. Now that was more relevant back when we used to talk mostly about paper records. I can tell you I was involved in some litigation years ago in which a big chunk of time was spent removing a reporter's notes from the set of records that he had. So first thing you do is make a copy, whether it's an electronic record or a hard copy record. That way you have a version preserved in case, it goes away or some field gets accidentally deleted or anything like that. What questions or issues have you all been running into, or what can we do to help you in what you're doing?
While people are thinking about that, I was reminded, I think it was even yesterday, that you also have a right under the Public Records Law to request to inspect the records. And so if it's something that you're not exactly certain what you want copies of, so you're casting a wide net, you have the right to go in and look at them. I know that they're going to be pushback and things like that, but there's got to be a way for you to be able to do that without having to make them make copies of everything and then give them to you. So that's a good reminder and often overlooked. That's
a great reminder. And the sort of silver lining of that is it's not clear that they can charge you a penny to look at records. The statute's worded in a way that your 11th grade English teacher might not have liked, because it's not crystal clear what modifies what, but there's at least an argument that they can only charge you for copies and not for looking.
Well, and to that point, the settlement we had with the McCrory administration by the Cooper administration includes an agreement that they will, the state will not charge for gaining access for inspection. So that's out there, at least to the state. Obviously, may or may not be binding on local agencies.
Okay, we started to get some questions in the chat. So the first one that I see is, if an institution doesn't want to give you the records and cites an exception or an exemption, most notably the one about personal and private information, what steps should we take before turning to litigation? Mike, you want to start on that now?
Yeah, I think part of what you do is to be clear that you're not asking for that information and get a better understanding of what it is they're talking about that they think is personal or private information. At the end of the day, and as Amanda's already said, there may be instances where they may not want to, but the institution can give you the information, and part of it is having that negotiation to say, what about it of what we requested is a problem? But the solution is not, well, then you get nothing. They can redact that which is private or personal, but it actually has to be private or personal. To say that there's a staff member at Shady Acres with COVID is not something that's personally identifiable. It wouldn't, in the libel context, that wouldn't pass the of and concerning element to name one person on a staff.
I can pull it up. That's a great point you make, Mike, about the fact that our statute does have a provision that says if confidential and non-confidential information are commingled, and these are phrases that only the General Assembly could come up with, if they are commingled, then the agency has the obligation to uncommingle them, and you cannot be charged for that exercise. So you can't be charged for their unscrambling of the egg. And I'll pull up that statute. What if a public body continues to meet, no masks, minimal social distancing, doesn't record meeting, doesn't stream, so you don't feel comfortable covering the city council meeting? Wow. That if all
You should
that's
write about that.
if
Go ahead.
I was just going to say, if all that's going on, you're in trouble.
The other aspect of it, and obviously it would give you some exposure to it, but under the open meetings law, you have an absolute right to record and broadcast those meetings. And so you could negotiate making arrangements to get a camera in there and be able to remote start it and things like that. It might be a little cumbersome, but at least to keep you out of the room. And a way to approach the situation using all this wonderful technology that we have.
Yeah, and Mike, this is a issue that came up this morning in some discussion at the or yesterday actually in the Press Foundation board meeting. But I feel like we have transisted a bit to a more collaborative world, that people are willing to share resources and things like that. And something like this might be an opportunity if there's a partner out there to be had, to try to get some help. Because you can certainly imagine a world. For a time, I was not willing to go into a courtroom because of my family situation. Mike's been in that position. We probably all have at different points. And so finding a friend who could collaborate, I think, would be useful.
And that's a good segue and commercial for our coalition efforts. Our sort of position is the public data is the public data. And certainly there are opportunities and times when going it alone makes sense because you're onto a particular set of information that others aren't covering. But if others are in the space, joining forces spreads the resources, and once the resources or the records are obtained, it's pretty rare to see the same story or article or broadcast about them, that everybody takes their own take on it. And so that collaborative nature has been powerful, both informally and then formally since the pandemic began. And I encourage you to seek out those relationships, because I think they've broadened a statewide network. At the same time, I frankly think the government is recognizing that newsroom budgets are shrinking, and so they've got a little more power to be resistant to requests for information.
Yeah, I think that's definitely going on. Mecklenburg County has a COVID-19 policy team that meets multiple times a week in private. This is separate from county commissioners. What's the best way to get meeting notes or behind the scenes dialogue? The county manager previously blocked access to a business recovery cover group, saying that too was private. So let's talk first about this policy team. And your starting question is, are they covered by the open meetings law and the public records law? the definition of a public body is slightly different from the definition of a public agency. And I don't know if you can pop into the chat a few more details about how that group got up and running. But if they were officially appointed to conduct advisory functions, then we would say they are a public body subject to the openness requirements of the open meetings law. And if they are essentially carrying out government functions, then they are subject to the public records law. So I would tackle it in a two-part way. I mean, first, get all the information you can about how the group was established, organized, operates, funded, where do they meet, all of that. You know, if they're meeting in the county commission room and they're funded with county funds or anything like that, then I think you've got some good arguments that they are subject to the law, and it sounds like they've violated it over and over. Okay, it's made up of city, town managers, hospital leaders. The question sort of gets answered by how they get there. Or did they make themselves up, or were they created? Because the open meetings law applies to any elected or appointed body of 2 or more members who carry out any of a number of delineated tasks, which include just giving advice. So being purely advisory doesn't mean that they're not subject to the law. Other questions? Or experiences. We'd love to hear if you've had good luck, if you've been able to sort of figure out a way to pry this information out into the public. Of course.
If you have a good one to share, throw your name in the chat and I'll unmute you.
You've probably seen I've been putting some links in there for the public records and open meetings law, and also the American Public Health Association publication that I referenced, so that you can pull them at your leisure.
And I'll put in the chat our 2 email addresses, Mike, in case anybody wants samples of these documents or anything.
And as a reminder too, we'll have this recording up on our site at the end of the day. So you can go back through. I don't know if you'll be able to see the chat, but we'll leave this up here for a little while so you can go back, click on those, bookmark them, and
Save the chat.
Yes, save that. So, all right. Well, with that, if there's no other questions, we got one more in right under the wire. So what kind of COVID data can universities provide specifically related to students and COVID-19 spread?
So your question implicates a couple of things. I'll talk about one of them and let Mike talk about the other. But you know, the same principles that we talked about with regard to getting access to information from public agencies would apply here. That is, they would, you know, not be exempt from producing information if it's aggregated information. You're not going to get a student's name from a university. If you succeed, I'd be interested to hear it, but I don't think you're going to. One thing that's worth delineating is HIPAA, the federal law that relates to medical information, only applies to covered entities. That is a term of art in the statute. A covered entity is either an organization providing medical care or a business affiliate like an insurance company. You know, when the football coach says he can't tell you if the star quarterback broke his leg because of HIPAA, he's either lying or mistaken. He's not a covered entity under HIPAA. The other thing that probably will get thrown in your face is FERPA. And and Mike and our partner Hugh Stevens just concluded a United States Supreme Court refused to take the case victory on some FERPA litigation.
Yeah, I saw a knock knock joke the other day that was knock knock, who's there? FERPA who? I can't tell you. The FERPA is not the, I can't remember what Judge Manning called it, the cloak of invisibility that universities would have you think it is. In particular, what we were discussing in the suit against UNC was the records of those found culpable, students found culpable of sexual assault, and whether we could get access to them under the public records law. Ultimately, the courts decided that the flexibility or discretion given under FERPA for universities to release, public universities to release that information was mandated by our General Assembly to be mandatory, that the General Assembly had spoken and said that that information was accessible. And as Amanda said, they, after reluctantly giving us the records, they, the state petitioned the Supreme Court, who denied the petition for writ of certiorari. But that's one of those things that if they're arguing FERPA, you know, call Amanda or call me and we can work through, does that make sense in the context? The one thing I'd say, and it's important to understand, is when you're talking about public information and public records and public this and public that, that absent a few exceptions under certain federal statutes, what we're talking about only applies to public universities and public colleges. There's a different kettle of fish with respect to private universities. Some exceptions to that involving private university law enforcement agencies, changed to the law after Nick Oxner's suit when he was in college, if my memory serves me correctly.
The other thing to know about FERPA is it only applies to educational records. Again, that's a term of art. That's a phrase that's in the statute. And that's what Judge Manning was sort of saying. Just calling it an educational record doesn't make it so. It has to actually be an educational record. And I don't think that COVID information, even if it were about a particular student, would be educational records. Well, Mike and I can stay on for a bit if others have things they want to talk about one-on-one. We're also happy to talk through the hotline just to answer any specific questions you might have that you maybe think of later or didn't want to do this afternoon, but we appreciate you joining us and hope you enjoy the rest of the virtual convention, and congratulations to all those award winners this afternoon.
Well, thank you, Mike and Amanda, and to all of you here, if you want to stay on, talk with Mike and Amanda, just let me know. Otherwise, feel free to drop off at 2 o'clock, just over under 15 minutes. We'll start the next session. We're going to continue the theme of data. For those staying on, I'm just going to move you into the waiting room as we get that set up, and then we'll let you all back in when that session is ready to start. So thank you again, everybody. Send questions our way and look for recordings of this and handouts on our site later today. Thanks. We'll see you all soon.
Thanks, guys.
Thank you.